Hey everybody, welcome back to the Law and Crime Network. I'm Michel Bryant. Thank you for joining me for the afternoon session here. As you know, we are in verdict watch. We've got not one, not two, but three live trials that we're dealing with here in all forms and fashions. So Connie Bell is an expert in the digital world there, obviously talking about a GPS device. In fact, Ann Bremner is with me, trial attorney from Dallas. Ann, I know the Garmin 255-7LMT is one of your favorite GPS devices.
Yeah.
Yes, it's tremendous. And that's the one she's talking about now. Just give us a sense of what this is going to be important for.
Well, I mean, you lay the foundation for the jury to know exactly what you looked at, how you did it, that you followed scientific method and protocol and chain of custody. So there's no issue about what it is, what it was, and how important it can be in the trial. But all those foundational elements, of course, need to be laid by this witness. They're not always that interesting, as you just indicated.
Yes. David Schoen, criminal defense attorney, also with us. First, thank you, David. Haven't had you on before. I appreciate you taking the time, so welcome.
Thank you.
So tell me, when we have this kind of information coming out through this witness to this jury, and it can be a little dry, still important, how do you make it as interesting as you can? How do you just give this jury what they need and not overdo it?
I think a key is to move through a witness like this. First of all, one would assume any reasonable prosecutor would start with something a little more sexy than this. This is a case that's sort of a scintillating case. Everyone has kids and college kids, and they know the scene, and this is a horrible crime. So we have these concepts of primacy and recency. Start out with something strong. In the middle, move through these forensic witnesses that have to be done, as Ann said. And then at the end, finish up with something much more sort of scintillating, the facts of the case. Remember, this, as you well know, this isn't a case in which, so far at least, the defendant has denied the crime. It's a mental health defense in the case, some of which, by the way, to me, seems like inconsistent defenses.
I think you're right. I know we're going to hear and talk more about that. Pacing, very important. Let's go back into the courtroom for more on this witness. So tedious though it may be, this is critical stuff because it is really the plotting of the location, according to this witness, of the GPS. We haven't gotten beyond, where was that GPS? In her car or elsewhere? I'm assuming it was in her car. Pinpointing her location on or about August 20th, 2015. That's when the murders took place. Ann Bremner, trial attorney, is with me. So we get the feeling that this lady's going to lay down this foundation, but let's talk about the bigger picture here. What about the crime itself that the prosecution says this defendant committed? The traveling between school, back and forth, lying in wait. Give me your thoughts on that.
Well, I think it's really important because this is kind of a traveling, tracing case, in terms of her premeditation and her thought processes, but also her access and opportunity. Remember in the Scott Peterson case, GPS was huge. I mean, that's a case goes back some time, but it was huge because he was tracked on GPS going out to the San Francisco Bay and looking across the bay, presumably for his wife and his unborn child, Connor's remains to surface. That was really damning evidence in a case where there's no crime scene and a really kind of dearth of physical evidence. So this travel, this proximity, this access, and the great lengths she went will all be shown through GPS.
Yeah, GPS has changed so much. When I got my first GPS, David Schoen, $800 for the big thing to sit on your dash like a toaster. Now what is it? It's a paperweight. That's what it is, because most people use their phones. But when you have an independent GPS device like this, it's almost old science these days.
Right, that's right. And Ann makes a very important point. That is that the prosecution has to prove every element of their case. And sometimes these days, because everyone watches these forensic shows, this stuff can be interesting. But one thing to keep in mind, I think, in this case in particular, because there's a mental health defense here, that varies among the states. And in Florida, the state has the burden of proving the absence of the mental health defense once that defense has been raised. In some states, the burden is completely on the defendant to prove the schizophrenia, for example. But in this case, since they put schizophrenia at issue, the prosecution has the burden of dealing with that. So that's important. And so therefore, it's more important in this case than in an ordinary mental health case where the crime itself has been admitted. Mental health is the only defense. More important in this case to do this forensic business and sort of dot all the I's and cross all the T's.
That is a great point, because we have certainly done cases where the opposite is true and the defense has that burden. Let's go back into court. One of the fun things about Florida is the jury questions. And while they're getting that all worked out, let me ask my guests. David Schoen, first, let me start with you, criminal defense attorney. How do you like this whole, the jury taking part in the questioning?
Well, it's very, very interesting, and it's really sort of the American way, or it should be maybe. But from a lawyer's perspective, it can be problematic. The judge, of course, is filtering them and going through the questions with the lawyers. So there is that filter there. But on the other hand, one often is surprised by the questions the jury has. And sometimes it's too late when you find out what they have. And sometimes those questions can steer the lawyers toward another area that they may want to pursue. Yeah. By the way, very unusual, the facial expressions from this witness. This is a professional witness, a forensic witness, and she's grimacing at questions and answers, and very odd.
Looks like they're going to read those questions, and then I will talk to you, Ann Bremner. Let's listen to the questions if they're about to do that. So that'll do it for Geraldine Bly. She was on the stand quite a while today. There was a back and forth on the cross. Then, of course, the jurors get a chance to ask questions. Ann Bremner, trial attorney here. I asked David about this, and I think to his point, you'd rather hear those questions now than when you're talking to them after the fact with the jury that went against your client, right?
Well, absolutely. Although when I was a prosecutor, I had a juror ask a question like this. He said, if the defendant has enough money to buy heroin, then how come he has a public defender? I mean, that was the question. And so, you never quite know. Of course, the judge will rule on the questions in advance in most circumstances, so the lawyers can argue that certain things should be asked, certain things shouldn't be asked. I've been around long enough to where I'm not crazy about questions. I mean, most of my career, they didn't have questions in most cases. And I kind of rely on the jury as a whole kind of signaling where they're kind of going. And I'd like them to have their collective sense of what they've heard decide the case, as opposed to people that take too many notes, or their notes disagree, things like that. And then the part about asking questions, it's the same things. That's why I have an adversarial system. Let the lawyers duke it out, not the jurors. And
they can get sidetracked, go running off on some issue that is totally different than your story that you're telling. David, in this case, seems like the jurors had some interest in other phones. If she analyzed this one particular phone, what about the others? And some of the answer was, well, one of the phones was kind of in a pool of blood, so we couldn't do much with that. But what does that tell you about this jury and what they're interested in when they ask about these other phones?
That's a great question. I got a couple of things out of it, actually. I was really heartened to see the jury's, at least the juror who asked the tech question, clearly is paying attention. He or she had exhibit numbers and a technical question and so on. So I think part of what they asked is wanting to see the full picture, but the other was a very specific technical question that shows at least one juror is following along.
Yeah, and now it gets us into that gray area about what you bring to the jury box, what you know and what an expert knows and how those worlds might collide. There is another witness on the stand in the Amato case. It is another, I think, a forensic expert. Again, let's go into the courtroom. So, it's a little plodding here. We're getting through some of the details on that Surface Pro. Ann Bremner here is with me. She's a trial attorney. Sometimes you have a witness that just by the nature of the subject matter, it's a little more plodding. I mean, what can you do about that?
Nothing. I mean, and the fact is, that's what we expect them to be. I noticed with the other expert earlier, like we get the expert that looks at the lawyer and then turns to the jury and gives their answer. And some of that's too predictable or trying to grimace or be funny or connect with the juror or jurors. Someone like this is fine. I mean, they're not blinding anyone with science. They're kind of the revenge of the nerds. I mean, the people that worked hard and they know the science.
David, you mentioned, we heard the word paladin in some of the earlier testimony from this witness. Of course, I'm so old, when I hear paladin, I think bonanza. But it's a whole different thing now. What is this paladin?
Paladin is a very commonly used among law enforcement, Homeland Security, and others, forensic analysis device. It allows them to make an exact, purportedly, mirror image of the digital device. It could be, as in this case, Surface Pro, it could be a computer, to find out all of the activity on it, including any deleted items. But it shows a great deal. It's a very popular program. There's actually a free version of it. And some of it's used just for forensic, to tell whether there's any malware on one's computer and so on.
Okay, well, let's go back to court and see what Paladin has extracted for this witness's testimony. Okay, now we're getting somewhere. Nicholas Stewart here, this forensic examiner, is talking about the websites visited by allegedly Grant Amato on his computer, and they include myfreecams.com. Kind of a misleading advertising there, since it costs you $599.99 to get 5,000 tokens. And what do you do with those? You use those to talk to your cam girlfriend. That's where we're going with this witness, and we will have much more when we come back to the Law and Crime Network. This is Florida versus Grant Amato. Come right back and join us.